Good afternoon, everyone. My name is Celia Chandler, and I'm a lawyer with Iler Campbell, a law firm here in Toronto, where I'm sitting today. Welcome to all of those out in Cyberland. This is our fifth in a series called IC Education, and we're really excited to be able to do this. I know many of you will have attended workshops that we put on in person, but this obviously allows us to present and speak to you wherever you're sitting, which is great. And for those out in Cyberland, we also have some people sitting in our boardroom with us here, and so welcome to them as well. A quick land acknowledgement. As many of us are settlers on this land, we pay respect to and recognize that we here in Toronto are on the land of the Ojibwe, the Anishinaabe, and in particular the Mississaugas of the New Credit, whose territory we are gathering on here. This territory is covered by the Upper Canada Treaties. The recognition of the history, contributions, and importance of Indigenous peoples must be connected to our collective commitment to make the promises and the challenges of truth and reconciliation real in our communities. And we're talking today about housing, and I think this really goes double for those of us who are living and working in the nonprofit and co-op housing sector, where issues of diversity and inclusion are so paramount. So I leave that with you, those who are working in the housing sector, to see how you can incorporate truth and reconciliation issues in the work that you do. So moving then into the topic of human rights accommodation and the duty to accommodate, I'm really focusing today on how those operate within the area of housing, because that's our specialty here at the firm, or mine anyway. But know that issues of human rights we're exposed to these in the media all the time. For example, some of you may recall a case that arose in Quebec 2 or 3 years ago, where a woman refused to remove her hijab when appearing before a Quebec court justice, and was told that, in fact, her hijab was compared to a hat and sunglasses by the judge who was presiding that day. So, even within the hallowed halls of the judicial system, there's a sense of misunderstanding, perhaps, on the importance of issues around accommodation. And that's just one example. We see these come up routinely in the news and in the work that we do. And I'll just pull up this little quote from the former Chief Justice of the Supreme Court of Canada, where she talks about the importance of human rights in society generally. But I think it really speaks to the housing providers when we see the final part of this quote, which says, if we are to live together in peace and harmony, we must find ways to accommodate each other. Truly, for those housing providers that I work with in the sector, the nonprofit and cooperative housing sector, that is, these issues of peace and harmony are somewhat elusive, but I think human rights may be the one route to getting there and understanding those human rights. Now, as I've already mentioned, most of the work that I do is with the cooperative housing sector, so I'll just briefly talk about what I think this means in the context of housing co-ops. Human rights are always considered in all the work that we do. Co-ops have a duty to accommodate. We're going to talk a lot more about that in the course of the next hour. As a result of accommodations, often housing provider boards, or in fact anyone who's providing accommodation, will be accused of being unfair, because some people are getting things that other people are not. And I think that's really something that hopefully you will see through the course of this presentation is an improper interpretation of what's happening. We'll talk as well today about how people use the language of human rights when they're actually referring to personal preferences. And I think some of that is as we become more familiar with human rights language, we start to misinterpret situations and try to fit them into the human rights box. one of the things I hope you take away from today is that accommodation details are really private. We have many privacy protection laws built into society in Canada, and issues around accommodation under human rights legislation are firmly within those as issues that should be kept private. I believe that co-op members and staff and others as well, while this is focused a lot on co-ops, certainly this applies to everyone, we need to be educated and we need to promote human rights in our communities. And so good for you, you've signed up for this presentation, and those of you who are here in person, thank you for that.
Can you come back to the previous slide? I missed something at the end.
I've just been asked to revert back to a previous slide. I'm wondering, sir, by someone here in the room, I'm wondering, sir, if you can look at the slides when we're finished, because I do have a fairly tight schedule to get through. So thank you. So what am I proposing to do today? Well, I want to cover human rights legislation at a very high level, and also, of course, then focus in on this duty to accommodate, which is certainly often misunderstood among the clients that I work with, and I hope today will help clarify some of those issues. Then I want to talk about another aspect of human rights legislation and how it relates to housing, and that is the need for housing providers to provide environments that are free from harassment and discrimination. And I'm going to talk about a case from the Human Rights Tribunal from 2 or 3 years ago called the Rouge Valley case as an example of where we got a little more guidance from the Human Rights Tribunal on the expectation. Then I want to touch briefly on this idea of competing human rights, which is where things get really interesting, where two sets of rights are colliding. And then finally, for those of you explicitly who are in housing, I think we often think about the collision, if you like, or the coexistence of human rights issues and behavior that maybe doesn't conform to the community standard, and where, in which cases, one might consider evicting on the basis of that behavior. And then I'll point you in the direction of some other resources, and that should take us through to about 1 o'clock. So, although I will take questions from time to time, I want to be clear that today is about legal information, not legal advice. So if questions are so specific that they look to me like you might be asking me for legal advice, I'm going to politely tell you that I can't answer those questions. And of course, you're welcome to call me this afternoon or tomorrow, and we'll set you up as a client, and I can bill you, and all of those good things that go along with being a client. So Human Rights Code. The first aspect of the Human Rights Code I want to talk about is how it applies in housing. I think most of us know that the Human Rights Code applies in housing, but I think there's some confusion about what kinds of housing it applies in. So the first slide I have here is a picture of two people, two homeowners, coming out their front doors. The gentleman on the right is saying something very sexist to the woman on the left. And many people might think that she could take him to the Human Rights Tribunal for making a comment like that. But the Human Rights Code does not apply between two homeowners. But let's move that scenario inside a housing co-op or any other kind of rental housing. Same scenario, gentleman on the right says something very sexist to his neighbor on the left. Some of you might also think that she could take him to the Human Rights Tribunal for that. But in fact, it's her it's her housing provider who has the responsibility to make sure that she's living in an environment that's free from harassment or discrimination on the basis of her sex. So while certainly our friend here on the right plays some role in that, it would really be her recourse to go down to the office. If she's in a housing co-op, for example, there might be a property manager or a coordinator there, and say, hey, I've just experienced this, and you, housing provider, have an obligation to do something about it. So that's the first aspect of how human rights applies in housing that I wanted to address. The second is how human rights applies in the context of all of the other legal obligations that a housing provider might have. So for those of you who are in the world of housing co-ops, at the third level of this pyramid, you'll see the documents that relate to the internal operation of a housing co-op. So housing co-ops have bylaws, they have occupancy agreements. For those who are in rental housing, you will have leases, you might have rules. These are all the things that kind of govern how you operate as an entity. And you know that within that context, if you've got some rules or some provisions in your bylaws, for example, that don't match what's in the provincial legislation, then it's the provincial legislation that applies, regardless of what's going on within your organization. And so an example, in the world of housing co-ops, almost 6 years ago now, there was a change to the way in which a housing co-op could evict a member. It used to be that we went to Superior Court for those evictions, and everything moved over to the Landlord and Tenant Board to be similar to the way in which landlords and tenants operate. Many co-ops have changed their bylaws to reflect that. Some have not, but even if they haven't, those legislative changes from 2014 apply. So at the top of this pyramid, though, I have something called HR code. So that's short for Human Rights Code. So you're going to think to yourself, well, gee, that's just a piece of legislation like the Residential Tenancies Act, like the Cooperative Corporations Act, and so on. But in fact, the Human Rights Code has what we call quasi-constitutional status in Ontario, and in the other provinces for that matter, where if there is a conflict, for example, between another piece of legislation and the Human Rights Code, the Human Rights Code always trumps. That's Trump with a small t, just to be clear. So that creates this interesting scenario where obviously if the Human Rights Code is trumping legislation, and legislation trumps all your internal rules, then clearly the Human Rights Code also trumps your internal rules. Why might that be significant? Well, in housing co-ops in particular, members of housing co-ops can collectively decide on kind of like a code of conduct, if you like, or other rules that might not fly in the landlord and tenant world. So for example, there are housing co-ops out there who where the members have decided they want to be pet-free. So they don't want dogs on their property. And I think we all can recognize that the Human Rights Code would say that if there's a dog that's required for some human rights related reason, and you know, the one that we're perhaps most familiar with is the dog that helps a person with a visual impairment find their way around. If you were living in a co-op which was pet-free, that co-op would have to bend that rule to allow you to have that dog. And that would be a human rights accommodation of the kind that we're going to talk about in a minute. But there may be all sorts of other reasons that you would have to apply the code, the Human Rights Code, instead of your own bylaw. So at the bottom of this pyramid, I have something called personal preferences. And the reason I've included that is because we are now in a world where people are starting to use language that sounds like human rights related language in order to assert or put forward their own view of the world. So in a housing context, you might hear somebody say, "It's my human right to smoke in my unit." In fact, the Human Rights Code says nothing at all about smoking, just to be very clear. And there may be code-related reasons why somebody might have a right to use cannabis, or perhaps even if it was an addiction, smoke tobacco, but that wouldn't necessarily enshrine that right to do so in their unit. Perhaps. I mean, I have to be very careful when I say things like that, because there may be cases where the code would apply. But typically, when people say it's my human right to do whatever I want in my unit, including smoking, they're really just saying, this is how I see the world. This is my personal preference. And so one of the things I hope you take away today is that there is a hierarchy of these things. The code is at the very top. Other things flow below it. And personal preference, regardless of how you want to pitch it, as a human right or otherwise, is at the bottom of the heap. I'm going to stop for a moment and just see if there are any questions from Fraser. No? Okay. Then I'll move on to talk now about the code itself. So in a housing co-op or in any other kind of housing situation, the Human Rights Code applies to you as a housing provider and as an employer. So I'm not going to talk about the employment side today, because this really was this session is intended to be about housing. But know that you have this other set of responsibilities to your employees, which are similar but a bit different. The code also sets out what we call protected grounds, which is just a fancy way of saying those characteristics that human beings have that we've decided should be protected are set out, are stated in the code. So what the heck are they, you might ask? Well, here they are. So I think most of you would not be surprised to see any of these on the list. We've known for some time that we protect certain characteristics under human rights legislation in order to correct historical discrimination that we've seen on these grounds. The one that probably comes up the most in housing, and in fact in employment as well, is disability. And disability is a pretty large category because it covers physical disabilities, whether they're temporary or permanent, and it also covers mental health disability and addiction. So it's a very broad category, and one that we spend a lot of time focusing on. But certainly these others are equally important. And I think one of the things we need to recognize, and this comes up more in the context of competing human rights, is that there is no hierarchy of rights. So if you have, we can't say, well, disability will always be the most important one. That's not the case. It's merely the one that we end up referring most to in the housing context. Yeah, I have a question in the room.
For the receipt of public assistance in housing alone, if somebody on OW is getting a minimal amount, and it will come up that at some point they're going to have problems paying the rent, not because they're on OW, but because of the small amount that they have, would that be considered human rights if you reject the application based on not the source, but the amount?
But the amount. So the question that's been asked by a person in the room is around the ground that's called the receipt of public assistance, which is the ground that applies only in housing. And what that ground means is that you can't discriminate against someone in providing housing because their source of income is public assistance. The question was, can you discriminate if the amount is not sufficient to make the rent or the housing charge? And my quick response is probably you should consult with your lawyer if that comes up, because anytime you're turning someone down for housing and one of these grounds applies, there is obviously a risk that the person who's been turned down is going to say, you've turned me down because of this ground, not from some other reason. So I know that's probably not the best answer. It's not the most satisfying answer, but I am a lawyer, so I have to be very cautious. But I think, it's a very interesting conundrum that housing providers get into when they're turning anyone down. The risk is there that one of these grounds is then going to be seen as the reason that they've been denied housing.
Even though it was a business decision.
Exactly, even though it was a business decision. So I want now to turn to the issue of the duty to accommodate. So what is accommodation? Well, I like to think of it as providing something for one member or tenant, what others do not get, so that member or tenant who needs accommodation has a similar housing experience as the others have. Let me show you a graphic that should help. So on the left-hand side of the screen, we have 3 people who are, frankly, cheating and not paying to see the game. But anyway, that's a whole other issue. And each one is standing on the same level box. Now that box is useless to the guy on the left, is helpful to the guy in the middle, and useless to the guy on the right? But they're all getting the same thing. So if you rearrange the resources so that the guy on the right gets 2 boxes, suddenly he too can enjoy the game. The guy in the middle doesn't need anything more than he already had, and the guy on the left didn't need anything to begin with. So this is a very nice graphic, which, by the way, I did not come up with, but the source is there on the screen. It's a very nice graphic that shows really the whole point of accommodation. Accommodation is being sure that everyone gets more or less the similar experience, and that might mean that resources get allocated differently in order for that to happen. I hope that's helpful. I know that's been helpful really to me and to just about everyone I've shown this to, as a really quick and dirty way of seeing the point of accommodation. So under human rights legislation, we have the Human Rights Commission, which is a body of the provincial government, which has set out a number of principles for us to use when we're confronted with requests for accommodation. And remember, accommodation is just, in the previous slide, it's just really the guy on the right has asked for something different from others so that he can see over. That's really what I'm talking about when I'm talking about an accommodation request. In housing, it's not going to be, the thing that's being asked for is going to be different. Might be grab bars in the bathroom, for example, or any number of other kinds of changes to the unit that might be necessary for a physical accommodation. These principles that the Human Rights Commission have given us are pretty straightforward, frankly. When we think about it. Respect for dignity. Obviously, anyone who's asking for help to offset any issues related to disability, for example, you would respect their dignity from the get-go. There's not going to be a set formula. You're going to have some conversation with the person to determine what's going to make sense for them. Thinking about the grab bar, for example, in the bathroom. Somebody who's 5 foot tall is going to need their grab bar in a different place than somebody who's 6'5". And so that's the kind of process of consultation you might have to go through. As a housing provider, you also need to be prepared to explore different solutions, to be creative. Grab bars may be an easy example, but there may be people who, for example, are in a walk-up, who suddenly become disabled, and you're going to have to think outside the box a little to figure out how they might maintain their housing, either in that unit or in another unit in the same building. And that's the kind of exploration that you're not only entitled to do, but are required to do, to be sure that whatever accommodation you as a housing provider come up with is something that is appropriate to the circumstance. The next principle that the Human Rights Commission gives us is around voluntary compliance. And I think this becomes an issue, for example, when if a housing provider is renovating their space, they're going to be thinking proactively about things that they can do in order to accommodate future disability-related needs when we're thinking about disability. And that kind of voluntary compliance obviously goes a long way to ensuring people can age in place, for example, which I think is becoming more and more a goal for housing providers and also for tenants and co-op members. And then the last principle that the Human Rights Commission has given us is a principle called undue hardship, which is the limit to which you are required to accommodate. Now, what the heck does undue hardship mean, you're going to ask me? Well, I've got some slides just on that. So it's a very high threshold, and you can consider two things, and only two things. The first consideration when you're determining whether an accommodation will be an undue hardship for you is its cost. So, financial cost, I mean. And if you can do it as a housing provider, if you can provide this accommodation without essentially fundamentally changing the nature of your business, then you are obliged to do it. And that might be canvassing the world for other pots of money that you can dip into, or it might be looking to your own resources, but those are your obligations. The second thing you can consider when you've been asked to provide an accommodation is whether something constitutes a health and safety risk, which is unlikely to apply too much in the housing context, but there may be examples that come up. And that's it. You don't get to consider anything else. So let's look at those two things in a bit more detail. So on the cost side, you've got some obligations to be creative and look for ways to minimize the cost. And I'm not a cost accountant, but I'm sure you all, in co-ops anyway, you rely on your external resources to help you budget if you need to. You make decisions collectively about how money is going to be spent. And this, factoring in issues of accommodation will be key to that. Now, of course, undue hardship, financial undue hardship, will vary according to how rich the housing provider is to begin with. So I know some housing providers where, putting in grab bars in every unit might be cost prohibitive. And I know others where putting in chairlifts in every unit would not be cost prohibitive. And so that's the reason that the Human Rights Commission has not said, you have to do it if it doesn't cost $1 million, because each housing provider comes with its own particular set of financial constraints. Moving on then to issues of health and safety. So in order to turn down a request for accommodation on the basis of health and safety, you'd need to look at 4 aspects of risk. would the accommodation lead to, what kind of risk would the accommodation lead to? How severe would that risk be? Pardon me, how likely is it to happen? And how broadly felt would that risk be? And there aren't too many examples, as I've already said, where health and safety would be an issue, but one that I can think of is, it's possible that if you were asked to put in a chairlift in a public corridor or like a public stairwell within a complex, it might limit the access of other people to get up and down those stairs, or make it dangerous for them to do so. So that's an example where that might be a consideration. I think on both the cost side and on the health and safety side, if you were thinking of saying that something was an undue risk, it's probably a decision you'd want to make in consultation with your legal counsel, because obviously the consequences of getting a human rights accommodation request wrong can be fairly significant if you're taken to the Human Rights Tribunal. I'm not going to talk a lot about that right now, but know that that's something you probably want to avoid if you can. Then some of you might be thinking, well, there may be some other issues that I'd want to consider if I was being asked to make an accommodation. One thing that comes up a lot is, housing providers will say, well, that tenant or that member knew that that unit or building was inaccessible, but they accepted it. It's not a valid reason to turn down an accommodation request. Other preferences from other members or tenants, not a valid reason. Others thinking it's not fair. I mean, I think graphic I showed you earlier with the three guys looking over the fence, we can see that in fact accommodation makes things fairer, not less fair. The business interest, that's not a consideration, and business inconvenience. So those are all not reasons for which a housing provider can turn down an accommodation request. Are there any questions, Fraser? Okay, so the question is, does the Human Rights Code require frontline workers to act when they hear discrimination in public places? I think because I'm really focusing today on housing, I think the next part of my presentation might help answer that question a bit. So hopefully by the time I've finished the next section, that will be clarified. Okay, second question? So the question is, could an accommodation be as simple as providing a washer in a unit for someone who requires it in a building where otherwise they would not be allowed? And yes, that's a very good example of an accommodation for someone for whom it might be difficult to get to the laundry room, for example, or it would be an unsafe place for them to be. A co-op or other housing provider might be required to put in the necessary modifications in order to allow a unit en suite. So the question is, if an accommodation is going to put you offside a building code or a health code, is that right? Would that be a reason to not do it under the health and safety aspect of undue hardship? I think that might be, and I think it's interesting because the health and safety aspect of undue hardship doesn't really get a lot of attention, but I think that may be a way that it might sneak into the analysis, is if the building code says no, there must be a reason that the building code says no, and that's in some cases going to be health and safety related.
Okay, still two more.
Okay. I think we won't take any more than that, so we'll do two more. Okay. So the question is bigger than my ability to answer, but the question is, why is the responsibility for some accessibility issues put on the housing provider, and why is some of it on the healthcare system? I think that's probably a better question for a politician. This is the way it is, and I operate within this framework. So, Give me one more and then we'll move on. So the question is, does the accommodation obligation apply to tenant or member applicants? And specifically, if someone comes needing a certain modification, are you obligated to do that? Short answer is yes, you really are obligated, but the appropriate accommodation, so you're obligated to provide an appropriate accommodation, maybe not the requested one. And I haven't spent a lot of time talking about that today, but that's sort of the difference between asking for a Cadillac and getting a Toyota or a bicycle. And I would say, maybe that unit is not the appropriate accommodation. But again, I would have that conversation with your lawyer before I said no. Okay, I'm going to move on. I want to talk a little bit about this Rouge Valley case. So this was a decision of the Human Rights Tribunal from 2016 and gave a lot of guidance, I think, to housing providers and how they and their obligation with respect to the environment they provide. So I'll talk briefly about what was happening at the co-op. In this co-op, it was a very badly divided community, and there was a lot of infighting between two primary groups. There were financial problems. Board meetings were lasting 4 and 5 hours at a time. They were financially not in great shape. And on that backdrop, there were a number of anonymous posters put up within the building saying some very vile and horrible things about individuals in the co-op. I wouldn't normally show this kind of language, but I want you to see for yourselves, and this comes right from the decision of the Human Rights Tribunal. I want you to see how bad it was, and then I'll move on. So this is an example of a poster that was put up in the co-op, in the halls of the co-op. So you get the idea. I'll move on. So obviously when those posters went up, the board and the staff of the co-op removed them, but they didn't really take a lot of positive action to try to stop further occurrence. They, after a few months, they put up some cameras, but the cameras were obviously fake, and so they didn't have any impact. They apparently had conversations at board meetings about it, although unfortunately they didn't document those conversations, so it's not really clear what they were doing. One of the directors was overheard laughing about the posters because of the spelling errors.
All right.
Sorry.
So I'm sorry, folks. You just lost me apparently for a minute, but I'm back now. So the board wasn't being terribly proactive. After a number of months, they finally issued a notice to the full membership saying, don't stop with the vandalism. But unfortunately, that wasn't seen as specific to these posters, and so that didn't really have much effect. And eventually, some 6 or 7 months later, after this began, they got some real cameras in place, and they finally shut the problem down. In the meantime, of course, the people who were targeted, the complainants, were feeling very unheard, right? There wasn't any attention given to them, even though the police were apparently trying to investigate, that they didn't feel that the co-op was really interested in helping them through this. And initially they went to the Centre for Equality, Rights and Accommodation, which is an organization based here in Toronto that provides support to people who feel their human rights have been violated in housing. And even through CIRA, that organization, they didn't feel that the co-op was really responding to their needs, so they eventually filed Human Rights Tribunal applications, 10 of them. And so over the course of the following 3.5 years or so, the Human Rights Tribunal process unfolded. After, I think it was 5 days of hearing, which was spread over several months and required countless people from the co-op itself to testify and relive a lot of painful things. The Human Rights Tribunal finally issued an order which was a very useful one for those of us who practice in this area, because this decision underscored the importance of housing providers providing environments that are free from harassment and discrimination, and having an obligation to become trained or to seek the kind of outside help when stuff like that happens in order to try to shut things down, investigate, and so on. And so this is a very lengthy 87-page decision in which each of the 10 complainants was awarded $3,000, which, you know, some of us think probably wasn't enough given the kind of experience they had. It also, this decision also obligated or creates for boards and other housing providers a greater obligation to understand what they should be doing in a situation like this. And ignoring a situation like this was definitely not the thing to do. You can imagine, though, the enormous strain that this had on an already divided community. So I think, you know, the cost of going through a process like that is both financial and also a community cost. And I'm sure, although this is not a co-op that I work with, I can imagine that the community rift that was already present when this all started to happen has not been improved as a result of this human rights process. So and there's a slide to talk about that. So that's a really quick run through of a very important piece of, a very important decision of the Human Rights Tribunal for the housing sector. And I encourage you all, if you have a fair bit of time, to read it in some detail, because it really does go through a pretty horrific story and help housing providers understand the really important obligations that they have. Any questions, Fraser, about that?
No questions.
Okay. There was that one question that around whether you have a positive obligation to stop things as you see them. It doesn't specifically address it in the Rouge Valley decision that I just discussed, because nobody was seeing it. It was all being done anonymously. But I would say, if someone had been overheard saying these kinds of things, the Human Rights Tribunal would well have expected them to take steps to try to shut it down. And so, for example, if there are racist or other kinds of discriminatory language used in a co-op members meeting, I think the chair has an obligation to set an expectation and stop that from happening if it has been. Yes, there's a question here in the room.
You mentioned that the co-op put in fake cameras at the beginning. So outside of the human rights element, would that also, should something have serious happen, somebody was hurt, would the co-op then also face other legal suits because of the fake cameras?
So the question is, what other consequences might there be for putting up fake cameras as opposed to real cameras? It's a little outside of the scope of this conversation today, but I think it's an interesting question. I think housing providers, and many that I've worked with, have put in place like a video surveillance policy so that it's clear on what basis cameras are there, for what use footage will be made, and if cameras are not real, I think people probably should know that. But it is, as I say, a little beyond today's scope. There's a question from Fraser.
Yeah, no need to repeat this since this microphone is right here.
Okay.
What if a co-op manager is regularly accusing members of violating their human rights? What obligations does the board have in terms of determining the validity of those complaints?
So you have a co-op manager accusing others of violating the co-op manager's rights. That's the question?
Co-op manager is regularly accusing members of violating their human rights.
Their own rights, the co-op manager's human rights, yeah. Well, as with any other human rights issue, co-op boards need to take it seriously and respond in some way, possibly investigate to determine whether it's valid and so on. I would need to know a lot more, and I don't want to know a lot more, but I would need to know a lot more to understand in what context that's all happening. Sounds like some education around what is and is not a human rights violation might be useful. Ultimately, though, it would be the board's responsibility to address the issue, both as the employer and as the in the housing context. Okay, I want to just touch briefly on the issue of competing human rights, because this gets quite interesting when you start putting two sets together. So, you may recall a number of years ago a case that hit the papers where a woman went into a barber shop in downtown Toronto and asked for a specific man's haircut. And the barber who was on duty at the time said, "I'm sorry, I can't give you that haircut because I can't touch you because my religion forbids me from touching women." And so she said, "Well, that's not fair because you're discriminating against me on the basis of my sex." And he said, "Yeah, but if you force me to do it, then you're discriminating against me on the basis of my religion." And so we have these two things, and then we have this, right? Head-on collision. So, unfortunately, we don't know what the Human Rights Tribunal would have said about that case, because although she filed her case, they apparently settled without it going to a full hearing and having a decision. But these cases happen in housing as well. And recall earlier I was talking about the case of someone who requires a dog for a disability-related reason. And that might be a physical disability, but increasingly dogs are present as emotional support animals as well. And if you have someone else living perhaps next door, or perhaps sharing a washing machine or using an elevator together with a severe allergy to dogs, then you have the very same thing, right? So these are issues that if housing providers haven't seen them yet, they certainly will. And I'm not going to go through it in detail, but again, the Human Rights Commission has provided us with a very handy policy on competing human rights, where they take us through a number of principles for how to analyze situations like this. And they also, in addition, provide us with a 3-stage framework for that analysis. So the first part of the analysis would be recognizing whether you actually have two competing rights, or whether you have, for example, a personal preference that's being put forward as a human right that's competing with another human right. Assuming you do, then you have a creative problem-solving process of trying to figure out how people can coexist. So, for example, in the case of the dog, if being together in the elevator is an issue, and you have 2 elevators, then maybe you make one where the dog can go and one where the dog can't go. If having dog dander in the dryer and washer is an issue, then maybe you identify some that are dog-free, and so on. It may not entirely please everyone. In fact, it may please no one. But at the end of the day, you have to then make a decision. I think if a housing provider has used this policy framework as a way to get to a good decision, and they've documented what they've done, then it's a way that they can justify or defend that decision if they were challenged. And keep in mind that if you're in a competing human rights situation, then you're potentially being challenged at the Human Rights Tribunal by both sides of the equation, right? Each person with a human right may be dissatisfied enough with the outcome that they will make a claim. But nevertheless, I think this particular framework is a useful one, and if or when a competing human rights situation arises, it's well worth taking a look at the Human Rights Commission website for that policy as a framework for working. So the last thing I want to touch on today is a flowchart that I have come up with as a way to help housing providers make decisions about how to handle behavior that doesn't conform to the community standard. And there's a human rights piece to this, an important human rights piece to this, and I'm going to take you through this flowchart. And for those of you who think in flowcharts, this will be helpful, and for those who don't, I'm sorry. And again, this is really in the housing co-op context, but I think it also applies in housing more broadly. So the first step, the first question to ask, and this is marked as box 1, is does the behavior that someone in your co-op or other housing situation, does their behavior violate the bylaws or your internal rules or your lease and what have you? So if the behavior isn't actually violating anything, then you don't have a human rights, you don't have an eviction issue for sure. You have a community issue. So over here on the left-hand side of the flowchart, you'll see a lot of arrows end up at the box 3 that's marked community building. And this is sort of against my own interest in a way, but the point of this slide really is to say that law isn't really all that helpful to you in an awful lot of cases. Problems are solved at the community level between human beings, right? So if you've got behavior that's bugging people but it doesn't actually break any rule or bylaw, then I can't help you. You need to figure out how to resolve that behavior within your community. So, but let's say it does violate the bylaw or break a rule, then my next question is going to be, is there a complaint in writing? And why is that important? Because if we ever do end up in any kind of legal process, if someone isn't even prepared to put their complaint in writing, then it's very unlikely that they're going to come and testify about it. So the first, level of trying to get commitment from potential witnesses is, are they prepared to put it in writing? If you can't get written complaints, then again, you have a community issue, not a legal one that I can help you with. But let's say we've got written complaints about a breach of a bylaw or a rule. Then we're into a bit of a classification process. So what is the basis for this behavior? And the reason I'm including this in a human rights seminar is because one of the bases for behavior that doesn't fit within the community sometimes is a mental health disability. And so when I say the cause of behavior is code related, I mean that somehow it's connected to a mental health disability that's protected by the Human Rights Code. And once we're into that territory, then we're over here on the right-hand side of my slide, where we're into a process of accommodation, where we're trying to determine what things can be put in place for somebody whose behavior doesn't quite fit, that will help them fit more easily into the community. And that accommodation process might take a very long time. You might be round and round in a circle trying to accommodate for a very long time, and you might achieve success, and then your problem is solved. And if you are unable to achieve success and you're unable to bring the behavior back into something that fits better, then you might be eventually into an eviction process, which is at the bottom of the screen. So, this slide obviously shows a great deal more than the issue of human rights, but I wanted you to see in kind of an analytical way where it fits in the day-to-day work that many co-ops and other housing providers are engaged in trying to help people maintain their housing, but help other people not live in communities that might be more chaotic than they need to be. And then, of course, there are some other kinds of behavior that I've included on this slide because this slide has a broader purpose, where you might also end up in an eviction if it's criminal behavior, or over on the community side if it's other kinds of troubling but not criminal or code-related behavior. So I hope that that's a helpful kind of one-page view on how human rights might fit on the mental health behavioral side. Fraser, are there any questions about that? I see my time is really just about up.
We have one question about would it be possible to get a sample policy?
Like a human rights policy?
I think so.
We do not have it. I know that for those who are working in the co-op sector, the Cooperative Housing Federation of Canada has a human rights bylaw, and I believe that the Ontario Nonprofit Housing Association, ONFA, has something similar. So there are resources out there, and the policy on rental housing that the rental housing and human rights that the Human Rights Commission puts out would also be a useful resource for people to look at. And so that actually is a very nice segue to my last slide, which is some other resources that you might want to look at. Human Rights Commission obviously has some excellent stuff, but CIRA, Cooperative Housing Federation of Canada, and so on. And for those who are not signed up to our blog, we do blog about this kind of stuff, and if you go to ilercampbell.com, you can sign up and be made aware of other sessions like this, but also some of the articles that we write on topics that might be of interest to you. So by the clock beside me, I see it's 1 o'clock, so thank you very much everyone for participating. I appreciate the questions, and I hope this has been helpful.
Can we ask questions now after you're finished?
I have one from online.
Oh, okay, I've got one more I'll take, sure. And then
Asking if you could please elaborate on what you mean by accommodation fails or uncooperative.
So, if the process of accommodation, which is intended to be a two-way street, so meaning both parties are engaged, if that person is not playing ball, as it were, not engaging in that process with you, then I would call that a failure of accommodation. And if you can demonstrate that you've been attempting to accommodate and you've been getting nothing in response, then that will certainly help you defend against any kind of human rights claim down the road. I hope that's helpful. Okay, I'll take one in the room and then we'll wrap her up.
Well, I had a couple of questions, actually. As you were saying at the beginning of your presentation, there needs to be a lot of education within for staff within co-ops, which wasn't there in the very beginning of the development of the co-op sector. For sure, this is something that's emerged in the last 20 or so odd years, it feels like. This is hugely time-consuming for staff to deal with these issues, you know, and which means that other part of their job description does not get done. So that is one question. I mean, how do you deal with that? Secondly, if there is a situation like in our co-op, we're, I think, a very compassionate community, and but we have we have 50% of our units are on subsidy, and we have a fair number of people. If they weren't in Bain Co-op, they would be on the street. Okay, because mental health issues primarily. In some cases, the behavior of individuals is very disruptive to their neighbors, to the point where people are afraid of the behavior of people. It's very difficult for our community to engage that, to even think about evicting people in those situations. Right? Often, though, in our community, they have a wide network of supporters, for instance, and they could, petition to overturn a decision by the board to evict, that kind of situation. So it's really complicated. It's really difficult to know, in that particular example that I used, like, what do you do?
So, so the question is, your first question was around how time-consuming it is for staff to have to deal with issues of accommodation. And I agree, and I can't, I don't have any magic solution to that. It is an obligation, it's a legal obligation of a housing provider. And so, the board or the landlord will need to determine how they want to allocate resource towards that in order to meet their legal obligations. The second question is around how complicated this is, especially if the goal is not to evict. So I couldn't agree with you more. It is complicated, and I think you end up engaging a lot in my flowchart at boxes 5 and 3. And if you're not prepared to go to the bottom of the flowchart, then that's where you end up, and you just keep trying things on both sides. And I think, the point I hope that this slide makes is that many roads lead to box 3, community building, and that's not law, right? That is working with community developers and community mediators and people who have softer skills than I have. And it's, I'm sure, it's a very rich experience when it works. And I've seen clients where communities have really turned around and approached these issues in a much different way. And that, I'm sure, is hugely rewarding for the people with those skills who help them get there. But it's not a legal issue. The accommodation stuff is, for sure. Okay. You're very welcome. I think I'll say goodbye now. Thank you, everyone.